Hi, everyone. Harry here to talk about the Voting Rights Act, which is 60 years old today and a really grave threat to what remains of it after the Supreme Court about 12 years ago really crippled it in the form that it had had so effectively for the 50 years before that. Okay, so in brief, high water mark of the Great Society legislation to many people. Voting Rights Act is maybe the most important legislative success story in American history. You can see in sort of broad sweep, beginning with the Constitution and its very imperfect treatment of race through the Civil War, fought for a national entrenched debate over slavery. Thereafter, a real retrenchment in the Reconstruction South in particular, which kind of continues. That is, at the time the Voting Rights Act is passed, even though the Constitution clearly says in its amendments, you can't abridge votes on account of race, there were a lot of tricky stratagems that states, mostly but not always in the South, were employing to dilute minority votes, especially votes of African Americans. And these were pretty blunt and crass. For instance, knowledge tests, literacy tests, poll taxes, all kinds of real sort of down and dirty ways to defeat the constitutional command. Enter the Voting Rights Act and the aftermath of the Voting Rights Act. So I'm going to be talking in a minute or two, hang in there, about Section 2, but just a very quick mention of Section 5 of the Voting Rights Act. That was really the main engine of the success of the act for 40, 50 years. And what it did, in conjunction with Section 4 of the act, it said there are certain states that are kind of in the penalty box. They have a real history of having done, nasty little maneuvers to abridge the voting rights of racial minorities. If you are one of those states, and Section 4 was to determine if you were based on the record, then when you purport to make voting changes, we're going to review those and you have to get pre-clearance because we're worried, given your history, that they're at least in part subterfuge to undermine and dilute the principle of one person, one vote. And that was a gangbusters kind of legislative enactment. And for many years, the states that were determined under Section 4 to be in this position had to submit changes. And I mean, changes, let's say we want to change the time of our voting. We want to change whether you can do voting by mail, things that other states do straight up, but you're worried in the case of these states might have a pernicious either motivation or impact. You had to submit them to the Department of Justice, a division, by the way, a section there that's now been essentially completely destroyed or taken apart by the Bondi administration. And they would give you a check mark or not. And that really was the sort of main thrust of the Voting Rights Act. And in 2013, and one other point, Congress repeatedly 3 or 4 times reauthorized exactly that. Section 4 and Section 5, the whole formula. They reauthorized the most recent time in the 2010 or whatever until 2030. Notwithstanding, in 2013, the Supreme Court got a challenge to Section 5 and Section 4 and just declared. It's a very odd opinion, Shelby County versus Holder, that really isn't based on text or congressional intent or whether, but just like, it's been long enough. These states, they were bad before, but they've been in the penalty box long enough. You just can't do it anymore based on these findings that were made in the 60s when it was passed, notwithstanding which Congress itself had said we want to re-up. But the court said, no, we're saying that Section 4, which puts the whole criteria for certain states that have to get preclearance into effect, is unconstitutional, at least as of now. Maybe Congress will repass it again. But for now, it's done. So there's a very big difference, of course, between reenacting or just extending a provision and actually a whole new Voting Rights Act, which is not going to happen in this person's, in the Republican Congress anytime soon or ever. I'll get to a little bit more about that in a moment. So what happened is Section 4 is done. So Section 5 bizarrely still exists. It says everybody in this box has to get preclearance, and who's in the box? Nobody. It's an empty box. So unless and until Congress passes it, that was a huge body blow to the civil rights community, but mainly to the principle of one person, one vote. Anyway, that's it. It's done. Section 2 then is where all the action has been for the last 12 years. And Section 2 says if states enact certain changes to votes, and the classic example here would be a gerrymandering resulting in redistricting. So they, right now in Texas, they're trying to take how many representatives they have, redraw the maps in the state, do them as gerrymandering happens, right, with these bizarre little shapes that are designed to cram into a couple districts the minority, or in this case, likely Democratic voters. You guys can win those two things by 98%, and we will maximize our victories in others. They're trying to do that. That's exactly the kind of thing that under Section 2, as it now exists, if it has the effect, super important word in the law, effect of diluting minority vote participation, or minority votes, then it's no good under Section 2. So Section 2 sets up an effects test. You don't have to prove that they were, they had racially invidious intent. Maybe they don't have any racially invidious intent. They just want all the power. Doesn't matter if the effect is to diminish. And any person, and this has been the case since the Voting Rights Act passed, any person can just come and say, I've been harmed. They redistricted here and my vote is diluted, and I want to challenge it in court. And you could, or you can still today. Okay, brings us fast forward to the present, and with that preamble that I hope is useful or worthwhile, given that this is, after all, the 60th birthday. Here's where we are now. Supreme Court last Friday issued its own order in a case that they had last year, a Louisiana redistricting case that they didn't decide, and they want to hear another issue. That issue, and it brought heart attacks to the civil rights community, is whether Section 2 is itself unconstitutional, Section 2 of the Voting Rights Act, because it conflicts with the Equal Protection Clause. Now, if you couldn't sort of piece together just what they were getting at, you have to look no further than an opinion by Justice Thomas. In fact, in this case, where he first said, we shouldn't have put this over, we should decide it right now, because he has in mind wanting to have any changes be in effect for the benefit of the Republican Party come the midterms. But his argument is, look, our Equal Protection Clause jurisprudence has changed over the last several years. Look at what we've said in affirmative action cases, etc. And we have come pretty close to discerning in the Constitution something like a colorblind principle. Many cases, for instance, where it violates the Equal Protection Clause rights of white persons, or in the Harvard cases, anybody, in the absence of race blindness. I think it's in Shelby County that Chief Justice Roberts says the way to end racial discrimination is to stop discriminating on the basis of race. It's a very dearly held tenet of many in the conservative movement that the Constitution should be utterly colorblind. So the question that is now up as of last Friday, and it's a rare thing, by the way, for the court to come out and say, address this question, which isn't even in the brief. So, there's intense interest in the court there. And indeed, that Thomas wrote this opinion. You can bet there's, 3 votes anyway from the get-go for it. And the idea would be the Supreme Court will consider whether the one part left of the Voting Rights Act that still has vitality, Section 2, is unconstitutional because it expressly sets up, and it does, a race-conscious principle. Now, the amendments after the Civil War, 13th, 14th, and 15th, and the 15th Amendment says you may not abridge votes because of race. And it has a section at the end that says Congress can pass legislation to effectuate this amendment. So that's what's happened here. Congress has said, look, we are effectuating an amendment that says you can't abridge on account of race. Of course, it's going to be race conscious. But you now have the possibility the Supreme Court will say, well, that's what you say in the statute, but that now comes into collision with the Equal Protection Clause as we've interpreted it. And it falls. And if it were to fall, it would, take what was, as I said up front, to many people's lights, the most successful or important part of the overall sweep toward racial equality and a more perfect union in the U.S. story, and kind of put it in the dustbin, a historical relic. Okay, one more legal point to raise, and then I want to get also to the present day landscape. There's also the possibility, there's a Circuit Court of Appeals that held in the last 2 weeks that Section 2 still has a race effects test, but guess what? You can't bring a lawsuit under it. Regular people can't. Congress didn't mean to let regular people do it, even though that's been happening for years. Only the Department of Justice, can bring those cases. So that would have the effect, even if the Supreme Court doesn't adopt this colorblind principle and strike down Section 2, if they adopted this, it would greatly contract the operation of Section 2. And when you had administrations hostile in office like now, and I mean now's like no other time, the history of Republican and Democratic administrations being vigorous and robust in their enforcement of the Voting Rights Act is very strong. But now you have these people who are in office who you have to expect, if only the Department of Justice could bring challenges under Section 2, it would just be moribund while they were there. So that's the other thing that's in play, and it's just good to know the consequences are big. Also, it's the birthday, but Section 5 kind of dead after Shelby County, unless Congress repasses it, and Section 2, where all the action is at real risk of falling, and most immediately. And this wouldn't happen for a year, although Thomas wanted it sooner, to a colorblind principle that they now discern would be superior and paramount in the Constitution, and therefore would make this huge statute have been, in the view of the current Supreme Court, unconstitutional from the start, unconstitutional over 60 years, because it always ran afoul of this principle they now discern of colorblindness in the Equal Protection Clause. Okay, just very briefly, after Shelby County happened, John Lewis, a member of Congress then and a early pioneer in the civil rights movement, crosses the Montgomery Bridge with Martin Luther King and the like. He had proposed legislation to re-establish the Voting Rights Act, Section 5, and do a lot of other things to kind of dust things off and make them more consistent with current modern day practice, mail-in voting and the like. And the John Lewis Act passed one house, didn't pass the other, but it's still sort of out there. So you'll hear, when you think about the Voting Rights Act, you'll hear on the one hand about the very peril that I just described and what the Supreme Court could do. And you'll also hear about a progressive agenda that if and when the Dems retake power when they did it last time. Number one priority, first priority, they couldn't make it happen, but is to try to pass the John Lewis Act, which, he's died, and it's sort of, in that sense, it had a kind of sentimental momentum. I don't want to be, jaded about it, but it's got that kind of reverence for John Lewis behind it, but it also has the real widespread understanding that, man, oh man, the Republicans have been making trouble and diluting however they can, and often with the approval of the Supreme Court, the one person, one vote principle. And that's, the most sort of fundamental thing there is. And that the John Lewis Act will continue, no matter what happens, to sort of be in the back pocket of the Democratic Party to try to enact if and when the time is right. Okay, so happy birthday, Voting Rights Act. So sorry that you've lost one limb with Section 5, and you might lose the next with Section 2. Everyone sort of stay awake to that possibility that the Supreme Court has ordered up. And then maybe in a future world, it will actually be revived, phoenix-like from the ashes, and even strengthened a little through something like the John Lewis Act. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.